do have skills that make me a nightmare for people like you.
Again, it's not just dismissal. It's showing that they're full of crap. It's embarrassing the troll,
right,
so to speak.
Right.
That is kind of a part of it. Can be part of the goal. Now, again, if you're embarrassing them to the point that it's shown that they're just presuming their whole ordeal, they're presuming that they should have even dragged you or your friends or whatever into court. You've won a lot more than a trial can ever win. There's something better than jury nullification is what I'm getting at. See, jury nullification is a Hail Mary pass. There is something far better here.
Yep. It's
Oh, well, yeah, you're absolutely right. You're absolutely right, but I'm thinking, what if I can't convince them? Because I believe you. I know this. I believe it. I'm on board.
No, this doesn't sabotage the next step. This doesn't even sabotage your choice of lawyers.
Sure.
Actually, if you were to want to find a qualified lawyer, this same thing is what we're doing here is what you do before selecting one. You get the full cause and nature of the proceedings so that you could find a lawyer who specialized in that. Let's say they say, well, listen, you can get a lawyer, blah, blah, blah. It's like, well, that's a fine idea. How about I get informed of the cause and nature of these proceedings so that I can properly shop for a lawyer who specializes in this cause and nature?
Well, that's
You see, they want you to shop ignorantly, spin the wheel. But shouldn't you know the cause and nature of what you're accused of so that you can find a lawyer who is experienced in that?
Agreed.
And they're not in jail, right?
Agreed, 100%. 100%, I'm 100% on board. And I'm trying to convince two friends who don't know all this stuff, plus I'm facing a kind of a racist judge panel, or not panel, but judges in this court, and they're not going to care. Eventually, if I make all this perfect argument, there's a good chance that because the local system is so corrupt, they're just going to push it through anyway, and then I'll be forced into a jury trial anyway, and so I'm preparing for both anyway, and trying to prepare them both anyway.
Correct.
I gotcha. Okay, cool.
Now, there's nothing wrong with all that except for the fact that I don't care if the judge cares. We're not there to... The troll is going to present himself as winning at every step of every move. It's that you're pointing out that his bosses are not going to be able to look at this transcript and go, he did a good job.
Exactly. That's the name of the game right there. It's making it look pretty on the transcript.
And if he knows that the next review or the next whatever of that transcript is a joke because he did such a bad job at informing you the cause and nature of the proceedings, or he wasn't able to make the show look good. See, that's his job. He's there to make it look like he answered. He's there to make it look like justice was served.
He's a
and when
convincer.
he has to shove you past being informed of the cause and nature of the proceedings, the more obvious that is, the more he knows it. And then we get into other steps. There are more than just the arraignment step. In your case, let's call it being informed of the cause and nature of the proceedings. There is voir dire of the jury. There's voir dire of each of the witnesses. There's cross-examination of each of the witnesses. There's presentment of your evidence. There's
my own testimony.
There's allocution. No, I wouldn't be putting your own testimony in, but allocution. He will deny you every step of every one of those things, and you can make it clear that he did so. And then he knows that every due process step he failed miserably at.
Yeah.
He had to shove past every step that you're supposedly entitled to.
I see.
And those are all called reversible errors, biases. Every step of the way, every time he does one, you're raising the point that he's showing clear bias and that he shouldn't be a judge in this instance, but he's pushing past that as well. You're revealing that he just showed a bias, and he's saying, no, I didn't. Even the question of it is important.
Right.
No, it's not just that he showed bias; that there's a reasonable suspicion of bias. so let me do a quick rundown of elocution. This is way past arraignment, and this is after trial. You've seen it on shows and stuff like that. You ever seen somebody get up and apologize to the family?
Oh, yeah, of course. Like victim statements or family statements or whatever?
No, not from the family, but from the guy who was accused and prosecuted and found guilty.
When he goes and says he's sorry?
When he gets up when he's in court, and he stands up and he faces he turns around and faces the victims or whatever, and he apologizes.
He just said, Gary, did you understand the depth of what he just said? When he says, I am sorry, it blew by your head. Well, I didn't want to linger on that point, but on TV, it's always that. All right, yeah, but that's just...
On TV, it's always that. It's always an apology.
Wow. Yeah, oh, sorry.
Okay. Yeah, I know, Tom, you're getting ahead of things, but let's hold.
It's crash course, sorry.
Here's the thing. In TV and in all this, it's always presented as like you're supposed to be apologizing, throwing yourself on the mercy of the court for your punishment. It's before punishment, basically. Now, allocution is supposedly a right you have to talk about why you shouldn't be punished or severely punished for your crime.
Okay.
It is your forum and it is your opportunity to speak on the issue of punishment. What everybody in the bar wants you to do is to throw yourself on the mercy of the court and accept responsibility and talk about how guilty you are and talk about how sorry you are.
Lick some boots.
If you've just, however, gone through a trial, a sham of a trial, wherein they denied you every, supposed right all the way down the line.
Like Lawler's Albrecht.
If you begin talking about every due process violation and every bias from the judge, and every time you were stopped from asking, voir dire of the question of the jury, when you were denied cross-examination, when they stopped you, shut you down, as you're talking about those things as being reasons you shouldn't be punished, you will be shut down. They will stop you from allocution, which is supposedly a right you have. So even the last right in the ordeal, they will cut you off from. Allocution is not right because they say it's right. It's right because it's ensuring justice. If you write a book about the rules of soccer, it's not right because you wrote it. It's right because you described soccer. With all rules that are called Malleum in se rules, and all rules that are due process, substantive due process, because those are the ones that coincide with ethics. Every substantive due process right I wholeheartedly support, and every malum in se prohibition, and every malum in se, like law, I guess you'd call it, I support. It's the other half that I don't.
Of course.
And it's not because they say it's right, it's because it is ethical, And giving somebody the opportunity to list why they shouldn't be punished and hearing them on that topic is ethical. So shutting them up on that topic is unethical.
And might doesn't make right. Might does not make right.
Well, if you let a lawyer talk to you long enough, you'll get your head turned around and think the opposite.
Because they're part of the game.
Part of the game. They're spending their whole time talking you into different ways of saying might does make right, because when it's them that has the might.
Right. Yeah.
Okay, so the idea that you have a right to a jury of your peers, for example, as another example I missed. Okay, what does that mean? Does it mean people who are chosen by the prosecutor and the prosecutor's team?
Nope. It means any Joe Schmo on the street.
Well, again, you're accused of being their bitch. So they chose 12 people who are also their bitch to be your peers.
Well,
that is only correct.
What they want. Yeah.
That is only your peers if they're correct. They're presuming that they're correct.
That's deep.
So in theory, you should have 12 people who are what you proclaim you are, which is not related and underneath them in any way, shape, or form, which precludes all voters, driver's license holders, anybody who hopes to get a pension, I guess, or a government, money or Social Security.
Yeah.
Anybody who has to worry about that prosecutor eventually prosecuting them. Anybody who has to worry about that city or state or whatever it is, giving them permits to build sheds in their backyards.
Worry is the key word.
Anybody who wants money or permission from anyone involved in prosecuting you.
Okay.
That is not your peer anymore, because they are, they are the other side's bitch.
Where's that? Where's that? Is there where are you pulling a definition for peer from? Because I've never looked one up.
From his own fucking head.
Ask them. I'm sorry. Here's another point.
Oh shit! Let me let my dog in. I'll be right back. I'm so sorry.
Gary, man, I'm telling you.
I got to get back to the be informed rather than informing. See, he caught me because I'm starting to give definitions. It's like, no. Let them give the definitions. Ask them what they mean by a peer.
Where the fuck did you get this shit, man? Dude, I've been listening to you for a year, and you blow my mind, man. I'm telling you.
10 years of chewing on these words.
Huh.
Well, more than 10. Shit, it was the 90s when I started this.
All right, I'm back up.
Okay, so let me. You called me out on something here. I don't want to inform you of anything. I want you to turn to the troll and be informed.
Yep.
Gotcha.
So when you say, "Do I have a right to a jury of my peers?" and they say yes, you say, "Excellent. What do you propose as my peers?"
Nice.
And then you ask why they're proposing that voters are your peers. Why that they're proposing that people who are hoping for pensions and Social Security are your peers. That seems to be very different from you.
Yep.
Why are they presuming that you're a voter, driver, tax-paying, whatever, that you are fully subject and consider yourself subject to them, when that is the very issue at hand?
Right.
The question on the table is, are you their bitch? And if they're proposing both people who are your equal, who are thorough bitches, they're presuming that they're right, and that judge is presuming that the prosecutor's right. And is there any evidence that these people are your peers?
Wow, challenging the actual jury. That's the voir dire. That's the voir dire.
That's the voir dire. They'll tell you the voir dire is your opportunity to get rid of 2 people, or 3 people, or 4, whatever they have.
Yeah.
That's bullshit. The question is, do you have any that are what you're calling peers? And why are you calling these people my peers? If you actually did the substantive due process points, there's one more. You should actually have to have evidence that you're correct before you drag somebody into court. Court is where they have the opportunity to show you to be a fraud.
You know what?
As a prosecutor. The general sense is that you're there as an investigator. You're there putting your Columbo hat on, doing your best Columbo impersonation with just a little question, you're just wanting a couple little confessions from them.
Yeah.
And you're leveraging those out. So things like, if you're there and they say, I'm denying this, it's like, well, I see. Is that based upon, was the problem with it some formatting or spelling mistake, or was it substantial, some basic problem that you saw? Did you have the right copy? Are you looking at the right motion? Things like that, right?
Yeah.
You're investigating.
Sure.
And then you might set that aside for a moment and say, well, if you're in denial about that, do I have the right to plead guilty here today? Now, I understand that that's a scary question to you. But
yes or no question.
It's a yes or no question, and it doesn't bind you down. It's just seeing what the possibilities are. Do I have the right to plead guilty here today?
Yeah.
I tell you what, 99% he'll say yes.
Sure.
Excellent. Thank you very much. Do I have a right to make an informed plea of guilty here today? And he probably won't answer that one because he sees where you're heading. Because he doesn't want to make his prosecutor, that troll, answer the questions.
Right.
So, excellent, do I have the right to make an informed? You might skip that one because you know it'll bring up a fight. You might want to ask some more softball questions. Like, great. Am I presumed innocent of the accusation here? And that's a nice one. Yes, sure. You're presumed innocent until proven guilty.
Yeah.
Am I presumed innocent of all elements of the charge?
Well, you see, that's a medium ball question. Do you want to do another softball, or do you want to start locking horns a little bit? So am I presumed innocent of all elements of the charges? And incidentally, the judge will know when you say this. This is what's going on in the minds behind the scenes, and why that question is. One of the elements of the charge is the idea that the rules, that the codes that you're accused of applied to you in the first place.
Sure.
And that's one of the things that should be presumed to not be true unless there's evidence that it is.
Unless they prove it.
And unless there's evidence. Now, proving is a matter of trial, but having evidence is before trial.
I see.
You see,
different.
Testing the evidence is a matter for trial. Having it to begin with should happen before. Like, has the prosecutor presented this court any evidence on the topic of jurisdiction? You see, you're not asking if any exists. You're asking if he's gotten it. You'll get it. You'll get it. That's the number one question.
Yeah.
Has the prosecutor provided any evidence to the court? Oh, okay, he has. Why didn't I get a copy? Oh, I did? Where is it? Wait a minute. I read everything I got, and I see no mention of anything that would lead me to believe that it's true that this court has jurisdiction.
Nice. I'm tracking.
You see this, yeah. So it's very embarrassing. See, in theory, they were supposed, the judge in the public relations has the job to turn to a prosecutor and say, by the way, you do have evidence that this court should take this case on. They only seem to remember that when it's a bureaucrat being moved again. That's the only time they remember that little thing. Because if you try to bring up a case against a government bureaucrat, they sure as hell will make you submit the evidence before bringing him into court.
Sure.
But they forget it. When it's a prosecutor, why make him do work? It's all about making the prosecutor not have to do work. Another side to that coin is what's called a Brady request.
Oh, how do you spell that? Brady what?
Brady, Brady. The name Brady. It's a Brady request.
Easy
it's
enough.
Related to discovery.
Okay.
Now, we're opening a can of worms, but to summarize it, back in not that long ago, someone went all the way up to the Supreme Court with the issue that a prosecutor has the obligation to not just give you what he has, but he actually has an obligation to try and figure out if you're actually guilty. And if the police involved have any history of perjury and things like that. Brady was a thing that kind of set up the boundaries that what the prosecutor is supposed to do if you indicate that he needs to do it. Okay?
Okay.
If you're telling the prosecutor and you ask for evidence, like what evidence is there that these cops and witnesses of yours are reliable, he's not just allowed to sit back and say, well, everything on my desk I'll give you a copy of. He's actually supposed to get up off his ass and go figure it out.
The judge.
And that's the Brady part.
Nice.
So what they do when they receive a Brady request...
Wait.
Oh, God. Okay, go ahead. A Brady request is to the prosecutor. It's open to the court. It's not like you have to hand it to him at all. You submit it in a certain way. You go through some formality to make sure everybody's on the same page. You've made a Brady request. That prosecutor, 99.99% of the time, and this is the Brady court case actually talks about all this, that it's so prevalent that these prosecutors will, instead of actually doing what they're supposed to do, they will say, we're giving you standard discovery, we're giving you everything we have, I'm not getting out of my chair, fuck you, and the judges will support them on that. However, the Brady decision is all about the fact that that's not cool.
Okay.
Even though 99.99% of the prosecutors do exactly that, and judges do exactly that, it is an absolute violation of due process. Or, well, that's procedural due process. But anyways, they talk, so a Brady request, what you will get in response to a Brady request is we have given you all discoverable materials. That's what they'll answer, almost almost all the time.
Okay.
However, they're lying to you in the sense that they're trying to get you to drop your Brady request.
Right.
And, oh, okay, great, thank you. They're trying to get you to say thank you instead of saying, wait a minute, did you get off your ass?
I see.
And do your job?
Can I say something?
Verify.
Okay. So they have, through a matter of procedural rules, eliminated a substantive due process right. Okay? Now, the difference between these two things is you got to be very, very careful about what is discovery and what is being informed. They're both related, but if you try to use discovery instead of being informed, they'll say, you don't have that right. That will. They can approve or deny any discovery things.
That's really
it's more of a discretionary thing.
Dude, that's
however, keep in mind that discovery and being informed, there's a ceremonial thing called discovery that is bullshit. There is a being informed, which is generally called discovery as well, sadly, which is extremely powerful and useful. Everything that is extremely powerful and useful has an equivalent with the same exact name that is bullshit.
Interesting.
That's how they've arranged everything.
So
Agreed.
you're saying that well-informed is the good side and discovery is the bullshit side.
Yep.
Well, they call it discovery either way.
Yep.
But there's always
they're hiding it from you.
I know, it's really weird. There's a lot of games being played. So, for instance, have you ever heard of corpus? Hold on, what am I looking for here? Bring forth the body. What's the Latin phrase?
Corpus delicti.
No. When you're imprisoned and you're trying to get somebody to be released.
Habeas corpus.
Man, I know this. Habeas corpus. Yes.
Yeah.
The writ of habeas corpus. So there are two things that are both called habeas corpus. One is the traditional point, and the other is a bullshit ceremony. And when you talk about habeas corpus, they will talk about a bullshit ceremony, and they'll say, "Oh, well, we deny that. We're not going to do the habeas corpus thing." And it's like, no, the habeas corpus is a fundamental point. Just because you have something that's called habeas corpus as well doesn't mean that's what I'm talking about. Let me be, to be clear. I am hereby challenging the imprisonment of someone who isn't yet proven to be guilty. Right. That is what habeas corpus is.
Right. Gotcha.
Habeas corpus is not the paperwork form that you can fill out at the clerk's office.
Right.
The Magna Carta is talking about barons and
Where
kings.
did this come from? All this ideology that you're talking.
All this ideology came from Greece long before the Magna Carta.
Okay.
Right. I mean, again, there was a big battle between Greece and Rome about dominance and subjugation versus equality, and that fight has been over 2,000 years in work.
Right. Interesting. And that's really interesting.
And what system do you think that the bar is, that the court
British, baby.
are? That is Roman. That is as Roman as you get.
Roman. Woo.
That is Roman. That is Roman in action right there. That is, the Rome became the cleric, became the Roman religion, and that became, they dressed the same even. But anyways,
no, wait a minute. Oh, now hold on.
There's two halves of law, two things called law.
Okay,
one of them isn't and one of them is.
If I've injured someone in one way or another, I am liable.
Okay,
now,
so malum in se, that's what you're talking about, not anything else.
Correct.
Go ahead. A prohibition that's being imposed.
Okay,
a prohibition that's being imposed.
We all understand that that's a bunch of crap. Now, what I'm saying though is, if we actually apply the laws the way they were designed.
Malum in se.
Yes.
If you enforced malum in se, I would have no objection.
Perfect. That's all I wanted to know. Great.
Okay.
That's it. I never heard him say that. Sorry.
Again, because we're using the word law, and as soon as you say law, I object.
I'd like a little explanation. What do you mean if they say law, you object?
Because law includes both. Law includes malum in se and malum prohibitum both. That's like saying, hey, sex is great. It's like, okay, but rape technically falls under that category. So let's just be clear to exclude rape. That's all I'm saying.
He dissects everything fucking right down to the nth point.
And he doesn't even smoke. That's amazing.
And I'm a mathematician.
I don't know. A lot of this started out when I did, so I don't know.
Does he smoke after sex? That's the question.
All right, where were we?
Where were we, right? Okay, so we went over a few basic points of juries, elocution, all these rights, supposedly. Oh, clarifying. You're getting in there with a little bit of a hey, I just have something that I'm confused about or not informed about. And leveraging that out to the point where you're getting that troll to do his job. It's like, do I have the right to plead guilty here today? Great. Do I have the right to, do I have the right to be informed of the cause and nature of these proceedings?
Sure.
Yeah. Great. Easy softball questions. Am I presumed innocent? Yeah, great. I'm softball questioning these so that he can't later on go against what he already said.
Gary, can I interject something here?
Go ahead, please.
If you ask, am I entitled to plead guilty here today?
Yeah.
A judge's MO, and this is just one example, he'll come back and say, are you pleading guilty today?
Well, okay, and that's perfect. That's awesome, because that answers the question. You can then come back and say, you know what, I have an I would say, hey, you know what, I even have an unsigned plea of guilty in my hand here. If you want to see it, you want a copy, I'm happy to give it to you. I just have a couple, quick things I'm just trying to clear up, and we can get this signed and get done with the day. And they don't like the habit of answering questions. I mean, lawyers go to school for years to figure out how to never answer questions.
Yeah, no doubt.
They know never confess anything. Yeah, he's trying to throw you off point and get you into the mode of answering questions instead of asking them. Right? I mean, it's a power move, right? If that troll can get you into the mode of answering questions, he wins, right?
Yep.
Sir, you've been saying you wanted to plead guilty from the beginning, so I'll take that plea. Slam the gavel, done.
Well, I'm sorry. I'm so sorry you've misheard, but maybe I should speak louder. In my intent is to plead guilty here today, and I have some questions.
Sorry, sir. Talk
Did you hear me well?
bailiff. Talk bye. That's what,
well, again, what actually occurred is still what actually occurred.
and that's what happened, brother.
I understand what happened to you. I'm very aware. And they might as well have not had you in and written down a fictional account of what happened and just pretended that it happened. It would have had the same effect. It would have been just as useful.
I have a question.
Please.
And this won't mean to sidetrack or nothing. It's okay if it's a 2-second answer or whatever. But when I hear Tom say that, where they're trying to rush him out, I hear, a judge trying to get rid of you, trying to treat you like a piece of shit, like you don't have any rights and everything. And I've heard some advice, and so I'll just bounce it off of you. And I brought it up in chat yesterday, and there seemed to be some questions about it. My advice was along the lines of, okay, well then we're gonna file a writ of quo warranto, or like a prerogative writ, and then like a writ of mandamus added to it would make it so that it would be like a cease and desist. It would carry a force to it that would make them stop.
You would file with his superior a writ trying to get them to order him to behave himself better.
Right. Exactly that. Can that come into play for Tom here?
And good luck with that, because when I was in court,
it's a discretionary.
Wait, can I just...
Bit of a different topic, yeah.
That's funny.
Well, so the idea that you can... Okay. So the idea that you can force them to behave themselves...
This is getting weird tonight.
...is all right, except here's the thing. The proper response to a failure to prosecute, okay, so when a prosecutor fails to prosecute you, the proper response is not to try to force him to do so, but rather to make the point that it should be dismissed for that failure. And I know that was a whole big package.
No. Yes. I heard what you said, and it makes sense. I'm just wondering for Tom's situation there. If what you're saying fell through, and the judge is trying to rush him out of the courtroom.
I failed.
You failed already.
The judge tried to pretend. The judge tried to pretend that he said he pled guilty when he said no such thing.
Right.
And instead of letting him object and correct the mistake, the judge ran away. Like in a literal sense, not figurative.
Right.
The judge ran out of the room so that he couldn't finish the thought. Now, again, Tom sadly said, is that all you're going to do, or is the record now closed? Which was a horrible question, but he didn't have a better one at hand. It was too quick. It caught him by surprise.
It happens.
He didn't know what. Yeah.
Yep.
So that is the last thing said. Is the record now closed? Like, that was all he had to object. That was his only objection. It's like, well, objection, point of clarification. If that would have been the last words on that record, it would have screwed the whole ordeal up for her. If he would have managed to say objection, point of clarification as she ran off, how is she going to run off when the last thing said is objection, point of clarification after she...
Then that's my fucking... That's, dude, Gary, you're killing me. That's a beauty. And I still have... All right, now, wait, listen.
Again, Tom, though, before that even happened, I had told you, anytime your mind says to you, what the fuck, the words out of your mouth, objection, point of clarification, right?
I love it. I'm writing that shit down.
It should be an automatic, when your mind says what the fuck, what comes out of your mouth isn't what the fuck. That gets in trouble. Objection, point of clarification.
Yep.
It is the formal way of saying what the fuck.
Okay, so
you've got to get this one. That's an important one, man. It took me a long time.
Okay, so can we pursue this just a tiny bit with the writ of quo warranto? Because doesn't it have to do with jurisdiction itself?
No, I know. I'll explain that it does, actually.
Okay.
I'll wrap it up. It's okay. I know. I left a little about there. So the troll's job is actually one step more than I've already explained. When the judge fucks up, it's the troll that should be objecting, not you. When the judge screws up the prosecution of the case and makes it impossible to seek justice, and makes justice and denies due process or threatens to deny due process, we object. But it's actually that troll that should be objecting because his case is being shit on.
Right. It's vulnerable on appeal.
If he has one. If he had one. No, it should be dismissed for failure for denial of due process.
Well, and what I'm saying is if he lets it slide and it goes through, then it would be vulnerable to appeal, and that's why he should speak up. Is that true?
Even before you get to appeal.
Yeah,
sure. If I'm a prosecutor, as soon as it happens and the prosecutor fails to object and you object and whatever, everybody should be objecting and agreeing against the judge. And if it gets to that next step, you should be already submitting motion to, you shouldn't be. There's a thought that you should be submitting a motion to dismiss for failure to prosecute. Right there.
If I'm a prosecutor and I really do have evidence of jurisdiction and a good case and a case, right? I do not want that judge to deny the defendant due process because it fucks up my case.
Exactly. If you are on the up and ups and that judge is trying to act like you're not, you would correct him. You'd be objecting. Objection, I want him to have this information.
It's called the
Objection, I want him to have
OJ.
this clarification.
It's called the OJ standard. Literally, they coined it, called the OJ Simpson standard. Every fucking I is dotted, every T is crossed, and you have the same right in a traffic ticket.
I see. Nice. Interesting.
So the idea, see, it's not for you to say when the prosecutor fails to prosecute, the best response, and I understand there's all these problems going on where they're in cahoots and they're going to steamroll you, but in pure theory, I guess,
right.
You should be turning to the prosecutor and you should be saying, thank you for failing to prosecute. I've been, you just basically shit-canned your case. Good job. Good job. Let's dismiss. Let's go home.
Yep.
When you say failure to prosecute, oh, go ahead. Sorry.
Yes. No.
Well,
that's a good question.
It was just clarification. When you say failure to prosecute, do you mean basically failure to do due process?
Yeah. It's all fail. He's got to be there insisting that the court does right.
Sure.
And does and helps him try his case.
Sure.
And does the courtship thing.
Okay.
Now again, when there's discretion, he can beg and you can beg, but that's discretionary matters. Due process is a different thing. He should be saying, "Hold on, that's a due process issue. Let's not fuck around with it."
Mm-hmm.
Right?
Mm-hmm.
And if he's failing to stand up for his own case and failing to make sure that his interests are actually served, although it's because he knows that his judge is on his side and they'll steamroll you together, but that threatens his case. In theory, it should be dismissed.
Sure.
He knows that they're all on the same team and they're all playing the same crooked game, and that'll benefit him. But he should be looking at winning justly, not winning because they cheated. If he had a good hand, he'd want the game to be straight.
Sure, absolutely.
Right?
Yep.
He'd want the rules to be everything above board.
Nicely said.
That's just common sense.
Right.
It's ethics. I mean, we are all about it. Listen, I'm an asshole, man. I'm a dickhead. But I'm telling you, the ethics of human beings is just the same. We just want to be fucking fair. Just don't fuck with me, and I will fucking not fuck with you. Simple.
Think about this. Let's say someone you loved was killed or victimized, and that prosecutor he had a solid case. He had all the evidence needed to prove the victimization and yada yada yada, and actually get it all the way through. Let's say he and the judge. Or let's say the judge was just being an idiot. Right, wrong, indifferent. The judge, wouldn't you be going to that prosecutor and saying, listen, you need to object to these judges' actions. I don't want this guy out on appeal. I don't want this guy to win because of due process violations, because of denial of process. And such. I want you to get this court in shape to get a good conviction.
I see, yeah.
And now, that guy would say, don't worry, this is my golfing buddy. We'll have this guy in jail in no time, But
it's like when they say the guy got off on a technicality.
On a technicality. That means they lost because they fucked up.
Yeah.
Because they tried to shove someone past a due process point or past and weren't able to get away with it.
Right. They got busted.
Gary, isn't this... Once upon a time, if I remember correct, you were saying that it's the prosecution's duty to make sure everything is proper. And you were saying something about holding their feet to the fire that way too. Is that what you were saying?
Very much.
Isn't that
failure to prosecute is a very, very big thing. His job is to prosecute you.
Yeah.
To prove you guilty, to give you due process, to make sure all of that's coming together. That's his job, not the judge's. The judge will help him, and the judge is, supposed to be all, superior to everybody, but, the judge will really pick up that job, no doubt about it. But it's not the judge that fails to prosecute. It's the prosecutor that fails to prosecute.
I'm following. I got questions if you got silence.
Leave.
Okay. Well, has there, I'm just wondering, the tail end of that just made me want to ask, has there been any discussion as far as addressing the issue when the judge starts to try and wear the prosecutor's hat? And just addressing it and separating the two in a very...
Yes, there's a very good point there. So when you discover that the judge is talking not about things he was given by the prosecutor, but rather he's offering either his own feeling on the issue or he's speculating on what's true, he's making his own assertions, so to speak, right? Rather than talking about the prosecutor's accusations. The question that comes to mind and maybe should be asked, you decide, is that based upon evidence from the prosecutor, or are you speculating that to be true? And that separates it back out. Is that something? Is that are you relaying something from the prosecutor, or are you just offering up your own thought on the issue? Do you have evidence? Are you is the judge intending to introduce evidence here?
Gotcha.
Or are you just telling me something about the evidence that's already been presented to you? Because I don't have record of this evidence that you're talking about, because apparently you guys had a meeting without me.
Right.
And so you can draw that line, certainly.
That's a big factor here, because it's in any small town, really. I imagine a lot of the judges know the prosecutors, and the prosecutor's career path and progression is up to the opinion of the judges and their loyalties to the court first, blah, blah, blah.
Right.
Hey, Joe.
Yeah.
Listen, this literally can be applied to any argument you have with anyone. If anyone ever disagrees with you, you can use the Socratic method.
And you're basically just determining if they're pulling it out of their ass or if they're basing it on evidence, and then you say, okay, great, let's talk about the evidence instead of what you think. I mean, Yep.
And if I'm wrong, well, I can see it.
Right, yeah. It's not because you felt that way, it's because the evidence pointed that way.
Yep.
So this can be applied to who, Tom?
To fucking
every argument, every discourse.
You two have never been married, have you?
Gary.
Ba-da-ching, ba-da-ching.
Well,
that's the exception right there.
See, I told you. That's why I brought it up. I'm devil's advocate.
Calling a discussion with a wife an argument is just not even honest enough to be.
Where's your jurisdiction, bitch?
Right. Sorry.
Doesn't rise to the level of argument.
Nope.
That's just lullabies. Nothing but lullabies.
My jurisdiction is in the bedroom, and you ain't getting any.
That just sounds like parrots squawking to me. So you see the judge and the prosecutor tag teaming, or maybe the judge is just starting to ask you questions that he shouldn't be, because that's the prosecutor's job.
Well, there's zero questions. No, it's nobody's job. Wait. Okay, they'll want to ask you questions.
Right.
But in order for you to answer any questions, you must first be informed of the cause and nature of the proceedings. Otherwise, you would be speculating about what they're asking, correct?
Sure, correct.
So all questions that they have for you, great. I'm going to make note of that and come back down around to that after I've been informed of the cause and nature of these proceedings so that I understand your question.
Well, sure. I agree with you 100% that, to bring it back to that. And I get that concept. But what I'm talking about is like the judge and the prosecutor are teaming up. And so your goal at this moment in time, hypothetically moment in time, is to split that up and to make it known to the court and the public watching that, hey, we're going to watch our rules and you guys are going to be nice, right? Because I'm just Mr. Helpless.
So that'd be a great opportunity for you to turn to the prosecutor and say, have you provided this court with any evidence of jurisdiction?
Yeah.
And if the judge steps in and says, blah, 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 it's like, oh, I'm sorry, did he give it to you? Did you get a copy and I didn't? What are we talking about here?
Yeah.
Again, you're backing up and investigating.
No, that's really important. Don't just say yeah. That's
No,
really,
I'm writing down.
literally challenge the judge to say, do you have a copy of this? I don't seem to have the same copy you do. That's really
he'll say, do you have this ticket? I don't know if I have that ticket. If you have evidence on your copy, then mine might be different.
Well, so what about this? So you could ask a question.
Any evidence of jurisdiction.
If you ask a question to the judge, you say, "Are you the judge?" And
you're asking the court, technically.
Okay, so you're asking the court, "Are you the judge?"
Huh?
And he'll say yes.
Wait. Do you understand what the court is?
Yes, I do, but I don't play their little game with it because I have that. I can.
No.
Sometimes I do. So you can. It's like.
So why did you ask that? I guess is what I'm kind of trying to figure out.
Because of this. This is why. Because it's just another. It's just another arrow in the quiver. Is the only reason I'm bringing it up, and it's like.
Maybe, but it's like asking somebody if they're Batman.
Well, that's not it though. Of course they go yes, and then your next question is, okay, is this the prosecutor to my right? And of course he's going to say yes. And I go, okay, well you're asking me this. Isn't that the prosecutor's job? And it just kind of puts him on the spot because it says what he just asked is actually a prosecutor's question, and this is.
If he asks you a question,
right? And
see now again, there's a difference. You got to watch it. If he is asking you a question to clarify your question,
well, no, it's a discovery type question.
That is not the prosecutor.
I'm talking about a discovery type question.
In our hypotheticals, there's always the accused is always going to have a question on the table, right?
Right.
That is number one goal. You're asking if you have a question relevant to
he said
you always have a relevant and unanswered question that is the topic of the moment.
Oh, this is
correct.
Okay. This is like a tactic you're teaching me here. So always.
It's every.
Remember the original hypothetical, the original premise.
Do you see what
that troll,
Gary?
That troll's job is to answer any relevant and unanswered question that you have. And once you have no question, it is time for trial.
Right.
So you have to have a relevant and unanswered question.
You have to stop saying right. That's my point. I guess.
No,
sorry.
Tom, he's okay. Tom, he's okay.
Know, but when you're in court, I'm sorry. It is so ingrained in me. In court and here, okay and right are the wrong fucking things to say. And so
I'm sorry. That is correct.
Clear. And I caught
Tom brings up a good point.
I caught him.
Tom brings up a good point. Remove that word from your vocabulary.
Okay.
That Gary.
That one too.
But let me, just for point of clarification, objection.
Great. Thank you.
Hold on. Okay. I wasn't.
Here's why we're doing this, because you actually need to rewire your brain not to say okay and right.
Okay.
And it's very, very difficult. I wasn't even noticing it, and Tom did. We do that. We say okay and right, and the courts use that, and they love it, because then they start feeding you questions and shit like that, to where right and okay sabotages yourself. They'll pick up on it. When you start saying okay, they'll start giving shit and getting you on the record as saying okay to all this horseshit. So you really never want to say that. And if you notice on videos and so forth, when someone asks a judge if he understands something, they will never say yes, hardly ever.
Yeah, no.
They will generally say, well, the words make sense in some way, but I don't understand, whatever they go on to say.
Yeah.
They will not say I understand, because
but they'll ask
again,
you
that paints them in a question.
Yeah.
They'll ask you if you understand, because you can only understand something if it's true and correct and without flaw and fully explained.
Mm-hmm. God dang, that's insightful too. Yeah.
Yeah, so basically they're saying, is this true? And if you say, yes, I understand, it means it's true. Well, if I told you 2 + 2 is 5, do you understand? You wouldn't say yes. You would say, that goes against what I understand of mathematics.
Yeah.
So there's something missing. Okay.
Yeah.
So if a judge says, you have the right, to blah, blah, blah trial, do you understand? The correct thing isn't, yes, I understand. The correct thing is, well, point of clarification. If there isn't if there isn't evidence of jurisdiction, would there even be a trial?
No, of course not.
Well, but they can't say that because that they have to dismiss it.
Oh, I said right again.
I don't know. I don't know. I don't know.
Well, you can't agree. I mean, it's not that you never agree. If they say, you have the right, you're presumed innocent, you can say right. You can say great. You can say thank you.
I don't know if this fits, but usually when people ask, they'll say, "Am I presumed innocent?" And the judge will come back and say, "Of course, the court presumes you innocent." And that doesn't. But he didn't answer the question, "Do you presume me innocent?" Because he wasn't asked that question.
A fine point there, Dan. Great point. You catch that he didn't answer the question you asked?
Well, you did, but usually people don't ask that. Do you,
No,
Mr. Judge,
Yeah.
presume me innocent?
Oh, and that's a phenomenal point, though, in the bigger sense too. Joe, did you catch in that what Dan just described? That you asked a yes or no question, and he answered something that wasn't the answer to the question you asked.
Yeah, I got the point that he made, the question that he made, but you were just saying about a diversion like
he didn't say yes or no. So you ask him, "Do you presume me innocent here today?" And the judge says, "You're presumed innocent until proven guilty." He didn't say by whom.
Right, and so he brought it by the judge or by the court. So that's what he was.
No, I mean, you've got to make sure that you got an answer to your question.
And so which one are you questioning is what I'm asking, I guess. When you ask that question, are you asking it of the judge or of the court?
Well, let's say you ask the judge, "Are you presuming me innocent?" I mean, we already know that the prosecutor doesn't. If you say in the court, and the judge says, "You are presumed innocent until proven guilty," yada yada yada.
We got
it's like, okay,
example.
Is that a yes that you presume me innocent? Because that was my question. My question wasn't about someone unnamed presumes me innocent. Because if you then later came back to him and said, "You told me earlier that you presume me innocent," or not, you presume me innocent. He can honestly say that is a bald-faced lie, and if you it's a bald-faced lie, and if you continue spreading that shit, I'll throw you in jail for it. He wouldn't go that far, but I'm saying, it's not far from the truth. There,
Yeah.
You've got to be very, very kind of pin them down because they don't like saying yes or no. It's very rare that they do. So you say, "Wait, my question actually was, do you presume me innocent right now?" Not, "I'm presumed innocent until proven guilty." That's a separate question. I didn't ask you, does anyone whatsoever in the whole world presume me innocent until some unspecified time? I asked you if you're presuming me innocent right now.
Yeah,
because here's the problem.
From fucking sitting in jail.
He knows he doesn't. He knows he does not presume you innocent because an innocent person can't get dragged into court.
And can't be put in jail to be held for bond. Hello?
Yeah. If you're innocent, that shouldn't happen.
Well,
and you can't put somebody innocent and drag them into court.
But and I'm not talking real world, I'm talking theoretical here. It could happen that an innocent person gets dragged into court and that nothing unlawful has, if I'm using that word correctly, I know how you feel about that word, unlawful has occurred against him just because there may be much evidence that would lead, like let's say a grand jury, to bring a felony charge, and yet he ends up or she ends up proving their innocence, or I'm sorry, let me rephrase that. They fail to prove it to a judge or a jury, and then they obviously all charges get dismissed. And so, they did get brought into court, and they were innocent. Is that true, or am I off?
Here's a question.
Yeah.
Is it an injury to put an innocent person through a trial?
According to me, it is. But who cares what I think?
Okay. No, you're onto something. An injury is when someone is without right harmed, right? Now, if you drag somebody into court who happens to be guilty, you've done no injury. If you drag somebody in court who happens to be innocent, you've harmed them. Okay? Just because you have a ceremony about it doesn't make it right. It's your job to make good and sure you only violate guilty people.
Devil's advocate
And that
question.
is why they should actually...
Wait a minute, Gary. I don't know if you meant that, but you don't want to violate a guilty person. You want to give the guilty person his due process, and then.
Well, okay, a guilty person. Okay, someone who is actually guilty, whether it's known or unknown. Okay, I'm saying they are actually guilty. Not that somebody knows it, not that somebody's so ignorant of it. They can't reach to ethics in order to escape being opposed upon.
Whoa.
Now, the devil's advocate question. Go ahead. You've got one lined up, and it's probably a good one.
Oh, I did until you just dropped that last sentence, and it threw me for a loop. Say that again, because it.
Oh, I don't know. What did I say?
I don't.
It's whether it's a guilty person, whether it's known or not, can't be injured by being brought to justice for the thing he did, like to a victim.
Oh, I see. Yeah, I remember my hypothetical now. It was
an innocent person.
Oh yeah, go ahead.
An innocent person, whether it's believed he was guilty or not, also the opposite's true. If he's dragged through court, he was injured. Now, granted, it might be he was injured because someone fabricated evidence. The jury or whatever might be like innocent, like drawn into it, innocent tools, because they were misled by falsified evidence. Now, if somebody is convinced to do something because of falsified evidence or because of, a kidnapping or whatever, they're not the actual one who did the wrong. It's the one who falsified the evidence who actually did the wrong. But if they acted without evidence, if they weren't even concerned with evidence, they're on the hook.
Sure they are.
That's why in a justice, if there was true justice, you'd be very concerned with making sure that you actually had proof that someone was guilty before you impose on them.
But you must see how that can be problematic. I mean, I'm not invested one way or the other. I'm just kicking this can around for conversation. But you can see how that might be problematic because crimes against people happen that are not documented, and the person runs away, and there is no proof other than eyewitness testimony. All those people are fucked.
Correct.
Yeah.
So if you're willing to risk injuring someone based upon that testimony, you're taking those risks into your own hands.
Yeah.
If it later came out that you were wrong to do so, you'd be guilty.
Unless you're hot enough and you're accusing somebody. I don't know. You're reminding me when you say that of all the false rape charges.
You understand how it kind of but you understand how the dominoes fall.
Sure.
If everybody considers it completely reasonable ethically to say someone's guilty based upon everything that's known, you're in the safe to move against that person, because if he turns out to be innocent, you're not going to be punished for having screwed up. Right. You may have to face whatever God you believe in, or ethically you'll be in the wrong. You'll have been negligent. You'll have been negligent in looking for evidence and yada, yada, yada. But that's all, that doesn't change the injury. An innocent person is injured by being dragged into court. I understand he may never get justice for that, but he was injured.
Sure.
A guilty person cannot be injured, and he's even benefited if he's let off free because of a screw up in the court. And in fact, the other victim was denied justice by that screw up or by that, But it's just, can you get everybody to help you with the idea of punishing somebody who you've accused?
Tough.
But it doesn't change the truth. The truth is someone's either guilty of being ethically violent or he's innocent. That's it.
Hey, can I ask a question real quick?
Go for it, Tom.
Joe,
yeah.
Did I read somewhere, I'm getting really fucked up, but did I just read somewhere you're just here for fun?
Huh? Do I sound like I'm here for fun? What are you even talking about?
Where was I here? I thought I was scanning through some of my posts.
No, he did say something earlier in this conversation where he said the risk to him on this is minimal, and the true intent is really to pave way for some friends and things like that.
Okay.
Yeah.
That's what I kind of meant.
But
Sorry.
Yeah. Okay. So his skin in the game is just a little bit of money, right? You're not facing jail. You're facing money.
For the most part, I mean,
Punishment.
technically, I have up to a year and $1,000 or some shit, like $30,000 or some shit like that. But even my lawyer's like,
you don't consider that to be risk?
no,
Yeah,
no. The question I have has to do with gamesmanship. So we're now off. We're not off the script. We're talking about how the script is delivered as opposed to the words themselves.
They'll say things that come across the transcript as being rather calm, and they'll say them beat red in the face and crap like that. They'll do things to manipulate how you perceive what's said versus how you read it later.
I see.
Keep that in mind. But go ahead with your question.
Okay. So, so my question is, and what I'm speaking to, gamesmanship is this approach of presenting your demeanor in a way that comes across, for very specific reasons that I'll give shortly, it comes across in a, yes, humble, but almost in a, just like a simpleton, like, oh golly gee, Your Honor, here I am, I'm just a guy. Yeah, Columbo, exactly, Columbo, exactly, right? Ho hum de dum.
Columbo is our mascot. If you can get down a internal Columbo voice, you're 90% there.
Okay, perfect. So I'm glad to hear that, and then that follows right into my next thing about gamesmanship, which is, now let's take it mid-level. Let's say the judge starts screaming at you, okay? Judge starts yelling, things like that. Now, my personal, weird thing, my personality, that shit makes me laugh. It makes me giggle.
Agreed.
Okay, I can't help it, and I've had to lower my face, freeze my expression, put my face in front of my hand and go, I'm sorry, I'm so sorry.
The absurdity of, again, they're feigning anger, right?
Right.
They're full of shit. Because this guy, a second after going beat red in the face and hollering, he would just, he'd sit back and pour himself a cup of coffee and forget that it ever happened.
Right.
Granted, sometimes, I'm not saying they never have anger issues. I'm just saying that they feign probably more anger issues than they actually have.
Oh, that's interesting to hear. Okay, so now when you combine those two, the Columbo plus the judge's reaction and whatnot to screaming, what I'm saying is, what do you think, here's the question, what's your opinion of an approach that faces a judge's anger, whatever temper tantrum that comes in a way that's like, with no kidding, a smile on your face, going, whoa, wait a minute, Your Honor, or Your Judge, whatever you like to address them as. Why are you getting so upset? I don't understand why you're so upset and being so rude to me. I'm trying to conduct business here, sir, and kind of make it like a victim. I'm the victim. What is this guy being crazy?
No, it's very good. It's very good. We encourage, for instance, when a judge threatens you with contempt, and they will, if you are doing well and they really don't like it, they might bring out a threat of contempt. And for instance, if they're it's like, well, is it a contemptible offense here to ask relevant and unanswered questions about the cause and nature of these proceedings? It's like bewilderment. Why are you personally offended by this question?
Right.
Are you personally offended that I should be wondering about this evidence? Is this blasphemous to some belief of yours that I should wonder if the prosecutor has provided any evidence of jurisdiction? And you're saying, it's like, are you personally involved in this matter?
Right. It's exactly what it is. It's asking for emotional investment. And if so, why? It's pointing to the ridiculous of it. We're here to do business.
Well, it's Socratic. You're here to be informed. I'm here to be informed. I'm asking questions, be informed. This is my business, I'm here in business matter. And you're asking...
Where'd you say you're from?
So you're asking, and you're bringing to the transcript the fact that he's red in the face, and that he's showing signs of personal investment.
Yes.
See, he knows what's saying that is being transcribed flatly. It's surprising sometimes to read what comes off of. Sometimes we have like audio recordings and transcripts, and it's like, wow, that transcript looks like a completely different event than that recording.
Oh, wow.
It's insane. They're very aware of the words they're saying.
Yep.
And they know to manipulate the inflections and yelling, and they know to manipulate that without manipulating the words. So the words just, it looks like a chat over a fireside coffee.
Yep.
And in the meantime, the recording, the guy's flying off the freaking handle.
Yeah.
So you've got to be equally aware. And the funny thing is, we're not as practiced at that, generally speaking. And you'll see the person look like they're stammering, bumbling idiots in the same transcript.
Yeah. Yeah.
And the judge is flying off handle, and the person is just being calm and trying to resolve whatever and trying to get through it.
Yeah.
But the transcript looks like the judge was sane and well-spoken and calm, and it looks like the guy was just all over the damn place.
Yes.
Like you.
Exactly what you're talking about. What you're speaking to here is
much.
exactly what I'm talking about, addressing.
Very
is the effectiveness of this conversation, this value, this importance, because, you know, so much information gets passed, and everybody here, we're also, if everybody just had the information, you know, we're in the teaching business, or at least the helping you if you want it business, and yet it seems to me that there's a lot of ignoring to this exact factor being an equal part, because what I'm saying is the teaching doesn't just have to happen online and through Skype. The teaching could happen because those people in the public are fucking, excuse my language, watching you. And if you deliver it with style and grace and like, they're picking on me and I'm just trying to be helpful, I'm not wasting time.
Yes, the Columbo approach.
The Columbo approach, yes.
The last point Gary made was very important, though. The record itself is just like when we type over here in Skype on the chat. It is so hard to inflect what you would like to be.
Sure.
You see what I'm saying? Sarcasm is lost. I mean, I've said things. The words can be taken in so many different directions. I've watched the shit I posted and went, oh my god. So that is what Gary's making a point of, what the judge is trying to make sure is on the record. The record is completely lost.
I see.
Yeah, and it's very good to have very brief, clear, unassuming, non-compound, unanswered, and relevant yes and no questions that you're asking, and you just keep coming back to them. Now, we haven't even managed to get into 1, 2, 3. Holy shit, Tom! How did you not get into 1, 2, 3 yet?
And I'm always pushing. Okay, that's funny.
Let me take a moment. Let me take a moment for my big contribution to the fucking whatever the hell this is.
Yeah. Okay. I'm always pushing, dude. This is like Gary's gem, and I'm always
all right.
But he's ready.
Let's get to it though, Tom.
Have sense. All right. He's ready.
So one of the main things that was coming back is people didn't know what to say. And they would just let the next step happen because they didn't know where to go. They were left without anything to say. Mm-hmm. They just were at a loss for words because of whatever speech just hit them, you know. And sometimes it was just pure hogwash. Like they'd say, no, you don't have the right to blah blah blah, and you know whatever it was, right? Just something that completely blows them out of the water. Mm-hmm. And over and over, and it's like. So I developed I identified, I guess, 3 segues to get back to the question you asked and to show that it wasn't answered or whatever it was, or to show the importance of why it should be answered instead of doing whatever the hell they're proposing should be done next, right?
Okay.
And the 3 segues are, the number 1 is the intent to plead guilty. My intention is to plead guilty here today. I have an unsigned plea of guilty with me. I am proceeding towards getting clarification of the cause and nature of these proceedings to get the prosecutor to state his case. And if he states a case and has one, I don't need to go through a trial. That is a burden that needn't happen. Because if he stated a case, if he's actually got a case and states it, we can just be done with this. I'm not even, it's actually senseless to go through a trial. I'll plead guilty. If he has one. Now, again, we know, and he knows, and they know, that if we actually start clarifying, he's missing pieces of his case. But that's beside the point. That's the unspoken, you know, that's the elephant in the room.
That's the point.
Right.
That's the elephant in the room for them, which is why they don't like that option. It should be what they want, but they don't want an informed plea of guilty.
Right.
They want an ignorant plea of guilty. But anyways. So number one is, my intent, listen, you're talking about a trial. My intention is to plead guilty here today. I'm just trying to get clarification on a couple points about his, about what he said and his assertions, so I can plead guilty. Mm-hmm. Why do you keep talking about trial dates? Why do you keep talking about that? You just said I had the right to plead guilty. Why do you keep bringing up the trial date and issues of trial? It's not about what's issue of trial. I can ask this at trial. I'm talking about pleading guilty here today. You're telling me to wait till trial. Mm-hmm. That doesn't make sense. Okay, so that segue helps you get back on the topic of being informed about the cause and nature of the proceedings and keeps you on the question.
I'm going to be using this on October 12th, just so you know. Keep going.
The second segue, and they're all true always, and they're all useful in some sense, but different ones are better at different situations. So number two segue is the gun in the room. For example, if they say, well, he doesn't need evidence of jurisdiction because you came, you're here, you're present here, you the court to do this, blah, blah, blah. The segue to get back to your question is the gun in the room. I am just here to deal with some threats of violence against me. If we were just in if we were just in a coffee shop discussing this, I could leave. Mm-hmm. Without you tackling me on the way out.
Right.
I could I have the option of not showing up, and an innocent person should have the option to say, I don't feel like coming today.
Sure.
But there's a gun in this room. I am under a threat of violence to behave in certain ways. Mm-hmm. If you put a gun to my head and say, I must now give you the okay to go to trial, I'll do so. But not because it's right, but merely because there's a gun in the room, because you were the one with the violent tools. You can actually force me with violence to do whatever you feel like doing. Not because it's right, but because there's a gun in the room.
Yep.
So if they're saying, we're just gonna, we're gonna give him till Wednesday to come back, whatever. We'll give the prosecutor till Wednesday to figure out what to do with you. Well, I'm only here to get rid of this threat of violence. I don't want to be under this threat of violence any further. I want to resolve this here right now so that I can be free of this violent threat. Nice. Can you please help me if he has provided you with any evidence that you have jurisdiction to put this off to Wednesday, to keep me here another minute?
Nice. Yeah.
The gun in the room segue brings you back to your question. Okay. The third point is the prosecutor's failure. We've discussed this a little bit. It's the failure to prosecute. It's the part where he should have done this before you got there. He should have presented the evidence of jurisdiction rather than just proclaiming it. He should have had evidence of it in his pocket. He should have been like, if anybody cares to see it, I got it right here. But he didn't, because he doesn't, generally.
I see.
So the third segue is the prosecutor's failure. So if they say, this is an issue for trial, or whatever they want to say, you could say, well, wait a minute. The prosecutor is supposed to be basing his assertion that this court has jurisdiction on evidence. Are you telling me that he needs time to figure out if he has evidence that he's supposed to have right now? He should recall it. He should know that he has evidence before he dragged me in here.
Sure.
He didn't care enough to check to see if he had evidence before dragging someone into court, and you didn't care enough, Judgy Wudgy?
Right.
to figure out if there was evidence that was sensible evidence of any sort. You just presumed it was out there. You assure me that you have jurisdiction, but is that assurance based upon evidence that he provided you, or is it just something you're figuring that you have?
Nice.
Is it just trust that you have in the prosecutor?
That's going to be
the prosecutor failed to give it to you, but you are presuming and assuring me that he has it without having seen it yourself.
Right.
And without giving me the opportunity to see it myself.
That's a party foul, man. Can't do that.
Right. That's the three.
So
that's the three segues that I tried to get back to your question. It's just a way to get rid of his speech and his proposed solution and his proposed let's do this again next month and whatever it be, and his speech about you're here because you wanted to be here or you're here because of your civic duties, whatever speech he comes up with or deflection he comes up with. Those are three things that I've identified to bring you back and say, you choose one. You know, there's some that'll work better in other situations, and if nothing else, it's like, listen, all that aside, I'm just here to plead guilty today. Always today, never right now. right?
Right.
Just saying, I might plead guilty right after he's finished informing me and clarifying his statement. Now, if they say, well, that's a conditional plea, you know, we don't allow you to have conditions on your plea. That's like saying, you know, I'll plead guilty if you pay me $5. Like, that's nothing.
Right.
But it's like, well, I'm sorry, do you accept uninformed and involuntary pleas?
This is gold, man. This is meat and potatoes. These are razor sharp arrows in the quiver. I don't know them, but I know them when I hear them. And I don't even have.
Right?
I mean, you know what I mean?
It sounds so damning,
yeah.
Right? What is a judge going to do when he's confronted with that question? There's no way out. There's no honest way out, I should say.
Yeah.
They've got to reach to.
Yeah, you should say.
They've got to reach through a threat. They've got to reach to, you know, ignoring ethics. They've got to reach to ignoring reality.
Mm-hmm. They have to.
And there's three buckets.
Hustle.
There's ethics. Right. There's three buckets in conversation. Anything you say can go in one of three buckets. It's a truth statement, a factual thing, like a physicist would agree with you. You know, this has this mass, this has this velocity, whatever it be. That's physics. That is manifest reality. And that's the only time that something can be true or false. That's, you know, it is either factually real or not, you know.
Yeah.
Then we have ethics. We have should. We have something that should and shouldn't be. That is called ethical. You know, we get into Kant and all that philosophy about what's right and wrong, rightful and wrongful, violent and nonviolent. That is that bucket. The third bucket is legal. And that legal bucket is just the whim and wishes of whoever is in the judge system, you know. The top judge who's involved in an issue, whatever the fuck he comes up with, that's legal. And you can't say what's legal. Because you can't predict what the highest level judge involved in an issue is going to feel about it.
Right. You're right, obviously.
So, and the highest level judge might be a different judge tomorrow. Oh, the next guy up had his hands into it, and he said the opposite. I have seen whole groups of people switch their opinion of something on a dime because the next judge up suddenly said, oh, this should have been obvious all along. And boy, people who were saying it's completely unthinkable turned around and said it's obvious. It was insane.
Humans are weird.
Insane how they do. It was a double jeopardy issue, and they were fighting them tooth and nail, saying it wasn't double jeopardy. We're pushing it through. It got to a judge. The same basic point that was made immediately got to a higher level judge, and he says, wait, this is a textbook case. The actual textbook case is almost identical to this about double jeopardy. It's obviously double jeopardy. This motion should have been granted before anybody else was involved. It should have been granted the moment it was raised. And then suddenly everybody, people who were saying, oh, it's not double jeopardy, can't even conceive of it, you're just completely off base, suddenly turned around and said, oh, okay. It's like, oh, my God.
Yeah, and it's crap like that makes me read a sentence like, or the Constitution is powerless to enact what it's saying. Because that right there is a complete failure. You cannot have that much discretion. I mean, that's a roll of the dice. There's no justice in that. That's remarkable.
And again, the legalities are always trying to make you think, okay, the judges are always trying to make the legal opinion look like reality and look like ethics. And get them all muddied up. They're saying, well, this is just a consequence of facts. No, this is just your opinion. You're ignoring the facts. There was a case in the U.S. where a guy was arguing he was legally dead, and he was arguing that he was actually alive to the court.
What the hell?
He was arguing that he was alive and he shouldn't be legally dead, and he lost his case. He was there arguing that he was alive and lost his case because he should be legally dead. He was legally recognized as dead, and they wouldn't change it. Reality has nothing to do with legal. And if you think the legal is like a consequence of reality, and that they think, oh, well, fact A plus fact B equals legal C, you're off in the bush. It's a completely mistaken view of what is actually kind of the point. And if you also think that most people it's unconstitutional. No, unconstitutional just doesn't mean that it makes you feel icky or you disagree with it. It's obviously unethical. Legality and ethics are completely separate subjects, and something can be legally enforced that is ethically repugnant.
Sure, happens every day.
And vice versa.
Millions of times.
Happens every day.
Yeah.
Happens every day. But they want to make it sound like they're just combining reality with ethics, and that equals the legal, and that's horseshit. And if you separate yourself from that and you say, wait a minute, just to be sure, you're setting ethics aside and reality aside to come up with your illegal nonsense here, right? And then it's kind of a lot of the point.
Yeah.
Do you have evidence of jurisdiction, or are you just pulling it out of the air? Do you have ethics to show that you should be forcing me to do something? Well, the only ethical thing you would do to an innocent person is leave them alone. So obviously not.
That gets kind of sketchy from my understanding, because it's obviously easy for me to understand, legal. Well, it's all written down, even if it's hazy and wuzzy. But the science, that's easy to understand. But then when it comes to ethics, it's like, well, that's kind of sketchy.
Well, there's a system. Well, there is a system of ethics that can be kind of called first principles. But let's not get too
right. It gets deep quick. I'm sure.
Yeah, it gets deep quick. As far as the legal thing, keep in mind that no matter how you read a legal decree from somebody, it's not your interpretation that matters. It is the interpretation of the highest level judge who's involved in the ordeal that matters. And if he is reading into it something that makes no sense at all, the black letter word or whatever, he's ignoring it completely, he has that prerogative. He can read into it whatever he feels like reading into it. He can interpret it however he feels like interpreting it. English has no bearing on the interpretation. You might as well be, the oracles, in Greek days. The legislature just comes up with moans and groans and shrieks, and the judges interpret it however they feel like doing. And if you're reading this and going, wait a minute, that clearly says ABC, judge can just turn to you and say, that's your interpretation.
Yeah.
I don't see it at all. In fact, I have 19 other judges behind me who found my D, E, and F in that writing.
Wow. It's madness.
It is.
But it's sure is fun learning it. It's like a second language.
Oh boy. Mark mentions it all the time where, he was in front of a very connected opponent in some case, and the judge says that he was reading verbatim a finding or whatever you call it, a ruling, He read it verbatim. He didn't rephrase it at all. He read it as a quote, and the judge says, well, that's your interpretation. He's like, what are you talking about, interpretation? I read it verbatim.
Yeah.
But the interpretation part is, you're saying, that's not, it wasn't related to what we're talking about here. So
it's crazy.
So as soon as you reach at statutes and so forth, they'll just say, there's always something they can go to where it's like, oh, you're not seeing it in its completeness. Just like religious texts. Every time you point at some passage, it's like, oh, well, you're reading it wrong. You've got to read it in totality. You've got to read the feeling of the whole thing, and then you get guided by the Holy Spirit or whatever. And they say it's your interpretation of a passage and a law and a statute is and a prior ruling is completely not relevant to anybody. You do have the right to be informed. So that's where we're leveraging this asking questions. You're saying, oh, okay, you say you have jurisdiction. what do you mean by that? Well, let's say they ask you. It's like, well, you say, what do I mean? Do I have evidence of jurisdiction? What do you mean by jurisdiction? And they're asking the defendant. They're asking you to clarify your own question, right? Which is legit. So now you're on the spot trying to define jurisdiction, and a lot of people accidentally try.
Yeah,
a lot of people accidentally. Well, there's an easy out to that. The easy out is, listen, I'm not trying to introduce any definitions here. I'm trying to clarify the prosecution's accusation. My understanding is, so far, that he says that this court has jurisdiction. I only mean what he means. So if you want to know what it means, ask him. What he means when he says this court has jurisdiction. Unless I'm mistaken, and he's not saying this court has jurisdiction.
Yeah.
I'm fine with it. Let's make note of that.
Yeah.
If he doesn't want to say this court has jurisdiction, let's make a note of it. Real big on the back wall.
Yeah, no joke.
So you're turning around and saying you're just there to investigate the prosecutor's accusation. I'm not here to introduce any definitions. I'm not here to introduce any facts, any rights. I'm asking, do I have the right to be informed? Great, thank you for saying yes. Do I have the right? You started only with questions, and they'll try to turn it into you defining shit, because if they get you to do a bunch of that, you're talking about your assertions.
Right.
And the prosecutor,
you're gonna stumble somewhere.
He doesn't even have to worry anymore. You're not talking about what he said. He can say, I never said freaking anything about that topic. I never brought up the Constitution. You did. You're asking me about the Constitution? I don't care about the Constitution. Whatever it be. I don't care, whatever topic.
Sure.
As you introduce topics, and people really, really get tempted to introduce, but the Constitution says blah, blah, blah. You just introduced that topic. It is not part of the accusation.
Sure.
And they can sit back and say, I don't care about your point.
So yeah, because then you're stuck with having to defend it if you introduce it.
Yeah. Now you're clarifying it. They can say, I don't see that is relevant. That's all they got to say. I don't see that has any application here. Doesn't seem to relate at all.
I once saw a video of a court where the guy submitted his jurisdiction challenge, and it was really funny to me. So, sorry, give me a second. So he submits his jurisdiction challenge, and then what the prosecuting attorney came back with to refute or to object to it was a completely different definition of the word jurisdiction. He kind of went into, well, because of his physical location, he wasn't here.
Yes.
Okay, so
he asked about jurisdiction, and they started talking about geographic jurisdiction or in rem or some other factor of jurisdiction.
I was in court, and I asked the judge if I could challenge jurisdiction at any time, and he says, yes, you can, so you can challenge it at trial. And I said, no, but I want to challenge it now. And he says, no, you can challenge jurisdiction at any time, so you can challenge it at trial.
He's trying to get you there with the way he's wording that.
Brilliant wording. Yeah. Absolutely true and absolutely misleading, right?
Yeah, yep.
Jurisdiction is a trial issue. Now, Mark says that's hogwash. I mean, he's taking a slightly different perspective on English than I am. So I understand what he's saying, and I agree with what he's saying, but here's my point. That is absolutely true and absolutely misleading. He's saying that it's an issue for trial, and then the question I'd have is, are you saying that it's merely an issue for trial and not an issue for right now, or are you saying that it's both an issue for trial and right now?
Interesting.
So they've misled you by saying, my name's not Tom. It's like, well, I didn't ask what your name isn't. I asked what your name is.
Right.
Very, very difficult to get them pinned down because they're pulling these weird maneuvers. But if you say, the prosecution as a prosecution provided any evidence of jurisdiction, he might say, well, we have personam jurisdiction because he was served this paperwork, right? That's a very common answer. Now, again, even the personam jurisdiction issue has issues because it presumes that you had a voluntary alternative of right of avoidance and all that, which is ignoring the gun in the room problem. But that doesn't answer the whole jurisdiction question. That's like pretending that jurisdiction was only personam jurisdiction.
Right.
It's like, and it's like, well, point of clarification. Is the prosecutor contending that he only has personam jurisdiction and that he has no other form of jurisdiction? Oh, no, not at all. That's not what he meant to say. Suddenly they'll back off, right? Because you just asked them, like, are you saying, just to be clear, that the only jurisdiction you have is personam jurisdiction? Because we can talk about that once you've admitted. So the goal in that is, sorry.
No, I was just going to say, I'm just hearing what you're saying, and it's flowing. I'm digging it. Keep going.
Right. Great. So one of the things, the tactics here is their position is that they have a million reasons that they have jurisdiction, right? But they're not talking about any of them. The thing you've got to do is avoid, no, you don't have to. The thing that you might want to do is avoid letting them present one at a time, and then you slash it in two, and they present another one. Because they always have, 999,000 left, right?
Oh, I see what you're saying. So you're saying instead of hooking them and then letting them escape and hooking them again, you want to encircle them so they can't run away and then hook them.
You've got to let them put all their cards on the table.
All right.
So you've got to say, what is your argument? Before I start knocking down this argument, I want you to completely say, I have jurisdiction because of A, B, and C. Then we can start looking at A is false, B is false, C is false, time to go home. If they say, I have jurisdiction for a million reasons, here's A, B, and C. You slash through A, B, and C? No problem. Here's D, E, and F.
Yeah, exactly.
You've got to ask them what they're asserting before you begin attacking, before you begin taking it apart. It's like, okay, just to clarify, are you saying that the only reason you have jurisdiction is because of my physical location?
Right.
Yes or no? Because they'll say, well, you were physically located here. That isn't answering your question. The question is, are you saying that you have jurisdiction because of my physical location? Yes or no? Is that an essential element or just a happenstance? So if it's shown that the physical location isn't relevant to having jurisdiction, do we go home? Or do you just get to pull another one out of the bag?
So encircle them before you attack, always. By isolating their...
In this instance, we're doing the Columbo thing. So, again, we're just getting them to put their cards on the table, which they don't want to do.
Right.
Their point is to avoid stating a case, because once they've stated a case, they can't reach to other shit. That is why the failure to state a case is so beneficial to them. They want to fail to state a case because the benefit it provides them is the ability to pull shit out of their ass later on.
Gotcha.
Once they've stated the case, they're stuck with what's on the table. And they want that option to pull in other shit. All of our shit's done and been shown to be hogwash. And you applied for a license back in 1982, so that too. No. When we started, you stated your case. You can't now reach off the table and pull in other shit and keep me busy forever.
I see.
Gotta have an end to the case. If they don't state their case can go on forever. That's why you want them to state their case. Even if you're going to trial, which is why this works, even if you believe in the state stuff. You want to get them to state their case so that you can't go to court forever. Now, lawyers benefit from open-ended cases. So a defense attorney isn't really going to want a stated case. Bring up new shit. Perfect. More billable hours.
Yeah, that makes sense.
Can I throw in a wrench here so he can understand this? Gary, are you not a resident?
Point of clarification. What do you mean when you say the word resident? I don't know that.
Well, Gary, don't you live at 111 Aloha Avenue?
Please clarify what you mean by living somewhere. I'm living right in front of you now.
Well, that's your house. Are you not the owner of the house or the car or whatever?
That's a great question. I know many people who contend that there's state people who contend that they own the house and that I'm just, living there by their permission. Are you contending that I own this house?
Well, your name's on it, Mr. Gary, and your address is there, Mr. Gary.
I'm sorry, you're asking me to clarify am I accused of having my name on a house? Is that what you're saying?
No, we have evidence of jurisdiction because you're a resident and you own the house, and therefore you're a resident of the city of
Point of
Hawaii.
clarification, we never did clarify what you meant by the word resident.
The resident means that you live there.
This reminds me of something.
Okay, just to be clear, when you use the word resident, you only mean I live there, whatever living there means. So could you
sir, you're a resident because you've... Didn't you vote for the mayor and the president?
I'm sorry. So when you say resident, you mean I voted for a mayor and president? So your evidence of jurisdiction is the idea that I voted for a mayor and president?
Yes, you chose your leader. Your leader now has evidence of jurisdiction, and you gave it to him. You voted for him.
So it's an essential element, and you have evidence that I voted for a mayor and a president. Is that what you're saying?
Well, we have a voter card. You signed it right here.
I'm sorry. So a voter card is evidence that I voted, or that I had the right to vote. You're a little unclear here because you said that I voted for a mayor and president a moment ago, and that was your evidence of jurisdiction. You're intending to prove that. I presume you have proof that I voted. Now you're saying that you only have proof that I had the ability to vote. So I'm just a little confused as to what you meant.
We have a form.
Now or you're lying then?
We have a form.
I'm getting a headache just listening to this. That's awesome.
Right? Right.
That's awesome.
There's always questions.
Yeah.
Anytime they're asking a question, there's sliminess in it.
And then
they're trying to mix in a word.
People wonder why Bill Clinton was like, it depends on what your definition of the word is.
That has a huge amount of legal history.
I'm sure it does. See, again, that separation between legal reality and actual reality. Yeah.
He was making that separation. He was saying, do you mean legally is or factually is?
Yeah.
What is a company factually? What is a corporation factually? It's nothing. It's an imagining thing. It's a legal fiction. A legal fiction has no physical manifestation.
Oh, bullshit. Corporations are people. What's wrong with you? How dare you?
No, corporations are persons. No one ever said corporation. In legal context, no one ever says corporations are people. They always say corporations.
Oh, that's right. This is 14th Amendment stuff. That's why.
No, well, not necessarily, because this goes back way further. A person includes fictional bullshit and real things. So you mash them together, you make a word. Like, it's like saying that whole rape, love, make, sex thing.
Mm-hmm.
A person is not specific enough to really figure anything out. It could be a fictional thing. A person includes Batman. Batman's a person. So it's like arguing about whether Batman or Superman has a bigger dick. It's completely nonsense because neither one of them exist.
Oh, I see, yeah.
It's like, well, Batman's not a person. Of course he's a person. He just happens to be fictional. He's not anything in reality at all.
You gotta get more specific. Yeah.
You gotta get more specific. If you say Batman's not a real person, I totally agree with you now. If you say Batman's not a person, you haven't been specific enough.
Yeah. I swear that, speaking of legal fiction, that case about the dead guy trying to be alive should be in like Black's Law Dictionary under legal fiction.
Oh, there's all kinds of stuff. There's all kinds of stuff about it.
That was hilarious.
It's wild, though. I mean, that he lost the case is the best part.
Yeah.
It wasn't just prove who you are. No, it wasn't. There was no question as to who he was. It wasn't about, we didn't properly identify himself. We can't trust that he's telling the truth. No, it was about the fact that he was legally dead.
Yeah. He was asking for a legal resurrection. Not a physical resurrection, and a legal one's a lot harder.
Right. It's like he was able to prove he's actually alive right there, unequivocally.
Too funny, man. This is second language bilingual stuff. It's too funny. I enjoy it. That's crazy.
There's a YouTube channel with this stuff. I might answer some of them in some of those videos.
What? Because I'm following like 60.
Well, okay, so my ID is GLCAPP on there, by the way. But if you search on YouTube, GLCAPP.
Got it.
GLCAPP.
Got it.
So if you if you search for arraignment foundations, you'll find some videos, and there's some of these calls in there what we've done in the past, and some court recordings and stuff like that too, all around this stuff.
Nice. I will look into it.
You don't have to follow. You don't have to follow. You don't have to follow my channel. I'm just saying, look at the playlist.
Oh no! Listen. No, I know. I would say that too, but I'm gonna follow your channel. I mean, come on. Look, I've been at it for 6 months. You don't just come across somebody who can speak like a lawyer and is just going one-on-one with a group chat, and you get a lot of your questions answered. I don't know a lot of stuff, but I know truth when I hear it, and I immediately just magnetize to this group, and that's rare for me. And it's because you guys go, we have proof. Here is the proof. Here's the documentation of the dismissal. And oh, by the way, if you disagree with me, come talk to me here. My door's open, mother effer. You got to. Well, let's do this. And nobody else does it. And that's how you know where the truth is. That's how you know to separate the bullshit from the. I just want to sell advertising on my YouTube channel like Alex Jones. You know what I mean?
Oh. If you feel like throwing this out there into the world, no problem.
Good luck.